Our next case involves some familiar faces, Florida Farm Bureau versus Jernigan. Counsel.
May it please the Court again, Elliot Kula on behalf of the appellants, Florida Farm Bureau, with my colleague Mark Upton. It is the same legal issue. It's why we move for these cases to travel together. They were briefed simultaneously, and the Court approved that request and allowed these cases to travel together and be argued together. There's slight variation in the facts and the dollar values in this case, but the legal issues are the same. In this case, with respect to the Jernigan's claim, $250,000 policy limits was paid out for the total loss due to flood. They filed a lawsuit to recover an additional $138,000.
Any claim by the Jernigans for the flood. The Florida Farm or someone just went out. Adjuster went to the property, basically saw it was gone, and said, correct, and wrote a check for policy limits.
For policy limits under the flood policy, the payment was accepted, and the acceptance of the payment is tacit acknowledgement that this was a total loss due to flood. And so then we're back full circle to the same arguments that we just heard in the Jernigan matter. In this case, of course, we don't have any issue with preservation, to be clear. In this case, it was actually teed up in an affirmative defense. Judge Lewis, I refer the Court to the record at page 493, where there's reference to the fact that the claim is barred, the plaintiff is barred from recovering losses covered by other insurance. It was argued in the same manner in the pretrial motions in limine. Same consideration was given to the notion of set off as a legal matter to be applied by the Court. And in this case, there actually was a motion, separate from the motion for new trial, there was a motion to apply the set off. The motion for new trial cross-referenced that motion in its concluding paragraph by referencing the set off. The post-trial motion was denied.
Did your affirmative defense expressly raise set off? I mean, I think it's the language, something like the Jernigans were barred from recovery for damages claimed to the extent that those damages included losses covered by other insurance?
That's exactly the quote. Barred from recovering losses covered by other insurance policies, and that's our record at page 493.
And that's the equivalent of set off, and you didn't use the word set off.
That's correct.
Which you'd normally see in an affirmative defense.
That's correct.
Okay. Let me ask a question. Here, is my memory correct? You've got a replacement cost of like approximately $280,000. Is that correct?
I'm not sure that that is the accurate number. The replacement cost, when you're talking under the flood.
I think the adjuster Kellerman may have testified to the cost around $280,000.
Yeah, I saw that number in your reply brief at page 12, and there was $250 already paid. And
then the lawsuit to recover the additional 138 policy limits for the wind damage.
Right. Are you, in your reply brief, you said there cannot be any award that exceeds the difference between the replacement cost and the payout under the flood policy, that is approximately this $30,898. Are you conceding that that might be a logical damage award since it for wind damage?
That would be the most possible. In this case, please remember this house was a $95,000 house for which there was already recovery for the total loss under a $250,000 flood policy. Now we're dealing with the wind policy of $138,000.
But the testimony on replacement cost was that it was $280,000.
That's correct. That is the number.
And
the actual number was not in the fire off, and I apologize for not recalling the actual number.
Is a flood policy a replacement cost policy as well?
The flood policy is either an actual cost value or a replacement cost. I would imagine the replacement cost value was paid in this case because there may have been some understanding that the house was going to be rebuilt. This was just a slab. So,
and again, in this case, as in the prior case, there was no apportionment between flood of causation between flood and windstorm.
That's correct. And if in Jernigan it was a failure to apportion that resulted in an excess recovery, in this case we're talking about a complete conversion of the.
Regarding that issue, Did Florida Farm produce any evidence to rebut the testimony of Mr. Mallett, the professional engineer, that the house was essentially destroyed by the wind before the water arrived?
I'm looking to my colleague to see if he recalls, because I don't recall. I'm sorry, I don't recall.
And was there evidence introduced, this may be a similar question, introduced at all about the damage caused by storm surge? Was that introduced in below?
There was some. It's consistent with the way the Jernigan case was tried. Some of this evidence did come out, but there was no evidence of the actual payment made, the dollar value paid out.
And again, there was a motion in limine and a ruling on the motion in limine which prevented that.
That's correct.
Okay. And you're not appealing that ruling on the motion?
No, we're traveling solely on the legal issue of whether or not there is entitlement to a set-off, okay, which we, again, as argued under the Jernigan case, respectfully request the court reverse and remand for application of that set-off.
Okay.
Thank you.
May it please the Court. My name is Matthew Bilmer, and I represent Ms. Voncille Jernigan in this action. The sole issue in this case surrounds whether Florida Farm Bureau Casualty should benefit from Ms. Jernigan's foresight in contracting for protection by purchasing both wind insurance and flood insurance. The standard of review in this case is de novo, and therefore this Court is only going to look at the trial court's decision as a matter of Florida law. Ms. Jernigan would like to draw the Court's attention to two key facts in this case. The first is that at trial, Florida Farm Bureau Casualty experts testified that Ms. Jernigan's home was damaged both due to wind and due to flood, yet they've refused to pay out a single dime underneath their wind insurance policy. Second, the jury's charge at trial was to determine if the home was a total loss in the legal sense of the term due to wind damage. And what they determined was, yes, indeed, the home was a total loss, actual total loss, meaning the home lost its identity, and a constructive total loss due to wind damage. Ms. Jernigan's arguments today surround two different legal theories. The first is the collateral source rule and its application, and the second is indemnity principles and the fact that they do not apply to property insurance contracts under the state of Florida. First off, regarding the collateral source rule, the Florida Supreme Court had a seminal case of Gormley versus GTE Products. And what the Florida Supreme Court stated was that the collateral source rule permits an injured party to recover full compensatory damages irrespective of any element of those damages paid by another source. And I quote the Florida Supreme Court here. They stated, "The collateral source rule rests on the concept of justice, that one should not be able to benefit from someone else's foresight in contracting for protection."
But, counsel, it seems to me that the collateral source rule is in conflict with Cox, at least the implication from Cox, because if Cox stands for, Cox doesn't stand for this, if Cox implies that apportionment must be made between the different causes of damage to a building in this type of situation, doesn't that just make it impossible to apply the collateral source rule?
Well, Your Honor, if that's what Cox implied, I would agree, but I would respectfully disagree with the idea that Cox stands for the proposition that you should allow for set-off. And the previous attorney that was up here discussed the fact that Cox does not discuss set-off. It simply stands for the proposition that if you determine there's a total loss due to a covered peril, that you pay out policy limits. And that's precisely what happened in this case. There was a total loss due to a covered peril. And in our case, there was, in fact, a jury determination that wind was the cause of the total loss. And if I could just briefly go back to Gormley.
But the trial judge here, and this isn't before us, the trial judge here did not allow a lot of testimony with respect to what damage might have been caused by flood, did it?
Well, Your Honor, there was extensive testimony about flood damages. Florida Farm Bureau Casualty argued that there was, ample amount of flood damages to the home. But again, the jury sided with Ms. Jernigan and stated that indeed the home was a total loss due to wind, not due to flood. But in fact, Florida Farm Bureau Casualty brought in the fact that Ms. Jernigan had a flood insurance policy and the fact that there was a payment of the complete amount of that flood insurance policy at trial. And they introduced ample amounts of evidence that stated that there was flood damage. The jury just didn't buy it. They said that there was wind damage and it caused the total loss. But moving back to Gormley, this double recovery.
Let's backtrack again to the motion in limine again.
Yes, Your Honor.
Was the motion in limine limited to the existence of the flood policy and payments made thereunder? Did the motion in limine also include the omission of any evidence regarding the damage to the home caused by flood?
I'm sorry, Your Honor, I don't really know the answer to that question. What I truly believe is that the first option that you threw out was exactly what the trial court ruled. And Florida Farm Bureau Casualty did introduce, if you go back and look at the record, ample evidence that flood indeed caused the damage. But again, the jury believed that wind indeed caused the damage. But this windfall or double recovery argument that Florida Farm Bureau Casualty makes, in light of Gormley, the Florida Supreme Court in Gormley squarely stated that there is no such thing as a double recovery or windfall because individuals could pay for years underneath their policies of insurance and see no benefit from that. Therefore, you can't take one bit of insurance and set it off with another. And again, that's precisely what Florida Farm Bureau Casualty is doing. Ms. Jernigan purchased her wind and flood insurance back in 1978 and has been paying premiums ever since. And underneath the interpretation of the 2004 valued policy law, as set by the First District Court of Appeal, in fact, in Springfield versus Boswell, if there is a total loss due to a covered peril, you pay out the policy limits.
If we look at the Louisiana cases and the principles of estoppel, and you look at, in this case, where the highest replacement cost for this house was $280,000, and the homeowner had already accepted a payment of $250,000, shouldn't she be stopped from presenting evidence that now her home is a total loss to the value, to the policy limits under her windstorm insurance?
Well, Your Honor, 2 points on that. The first is that Ms. Jernigan's experts testified at trial that her home could be rebuilt in excess of $300,000. Secondly, these Louisiana cases, I believe that Florida Farm Bureau Casualty argues these Louisiana cases today because Florida law is squarely on point with the collateral source rule and also indemnity principles. Each one of these Louisiana cases rested on the indemnity principles in their application in Louisiana, and they are wholly different than indemnity principles in their application in Florida. They cite to Esposito, Halmakangas, Perrion, and Ragas, and each one of these cases says, and I'll use a quote from Ragas, it states, insurance contracts are contracts of indemnity. Therefore, this person should not be allowed to get a double recovery or whatever. But underneath Florida law, it squarely states, and this case decided it in, or this court decided it in Springfield versus Boswell, when they weighed the valued policy law and specifically whether indemnity principles apply. And they specifically found, not the minority rule that indemnity principles apply, but they held with the majority rule or the New York rule that indemnity principles do not apply. If there is a total loss due to a covered peril, you pay out policy limits.
Is there any constraint to that? Let's assume that you have 3 insurance policies, 3 covered perils, all policies covering the full appraised value of the home. Can a homeowner in that situation where a jury finds one of those covered perils causes the total loss recover under all 3 policies?
Well, Your Honor, underneath the application of the 2004 valued policy law, yes, I would agree with that statement. And indeed, Springfield versus Boswell, the plaintiff in that case, was covered, his home was covered for fire insurance underneath 2 concurrent policies. And the court, when they decided, they said, yes, you can recover under both insurance policies because you paid a premium on it. Therefore, you deserve exactly what the valued policy law allows you, which is a total payout of policy limits. And I'd like to just address briefly some of the cases that Florida Farm Bureau Casualty cites in regards to indemnity principles in Florida. The first case that they cite is Disapetez. In addition, they cite Berkshire Mutual Insurance Company versus Moffitt. And I think it's important to note that there are no Florida courts that hold that indemnity principles apply to property insurance contracts underneath the valued policy law. In Disapetez, it dealt with an automobile insurance policy. And in Florida, there are 2 different types of insurance, valued policies and non-valued policies. Valued policies are governed by the valued policy law. In Disapetez, there was a non-valued piece of insurance, automobile insurance. And the court stated, indeed, that indemnity principles may apply. But again, we're dealing with a value policy here. Secondly, in Berkshire Mutual Insurance Company versus Moffitt, again, it dealt with personal property insurance. And personal property insurance is not covered by the valued policy law. Now, I think it's interesting that Florida Farm Bureau Casualty doesn't even address the collateral source rule in their reply brief. In addition, the only additional cases that they cite as proving that indemnity principles supposedly apply to property insurance contracts in Florida are 2 Florida Supreme Court cases, Glen Falls, decided in 1949, and Sperling, decided in 1976. But I'd just like to note that both of these cases, although they mention the word indemnity, they do not stand for the proposition that indemnity principles apply. Glen Falls and Sperling were both cases that dealt with depreciation. The insurance company didn't want to pay out underneath the policy, for instance, in Glen Falls, because they said your roof was 10 years old, therefore we're going to deduct for how much we should pay you. Each one of these cases is not dispositive of this case, and I just point to the First District Court of Appeals opinions in Springfield versus Boswell, and again in Rutherford versus Pearl Assurance Company, as holding for the principle that indemnity principles do not apply. And these Florida Supreme Court cases, especially Sperling in 1976, did not overturn the First District Court of Appeals decision in Springfield and Boswell. And it didn't because they're two completely different issues. This First District Court of Appeals squarely addressed as to whether indemnity principles applied, and they found that it did not.
And refresh my memory on those cases. They found that it did not because they were value policies?
That is correct, Your Honor. Absolutely. And they really held in the spirit of the valued policy law, which squarely states that if there's a total loss due to a covered peril, you pay out policy limits. And that's precisely what the jury determined in this instance, was that wind caused a total loss. And Florida Farm Bureau Casualty, makes the argument that flood damage caused some of the loss. But again, total loss, in the legal sense of the term, there's actual total loss and constructive total loss. Actual total loss means that the home lost its identity due to wind. And that's what the jury found, that the home lost its identity due to wind, and also constructive total loss. Other than that, Your Honor, I believe that Ms. Jernigan, unless this panel has any more questions, would like to rest on her briefs. So in conclusion, the collateral source rule bars Florida Farm Bureau Casualty's request for set-off. In fact, the indemnity principles do not apply to valued policy laws in the state of Florida, and therefore Ms. Jernigan respectfully requests that this court affirm the trial court's denial of Florida Farm Bureau Casualty's post-trial motion for set-off. Thank you very much.
May it please the Court, just a few points to clarify. I had addressed the replacement cost, the $280,000 replacement cost. That is paid if there is an intent to rebuild. If there is no rebuilding of the structure, then we revert to an actual value, and in this case that would be $95,000. Just wanted to clarify that because I wasn't as precise as I would have liked to have been.
What does the record reflect about an intent to rebuild here?
There was no rebuilding. There was no rebuilding. It remained a slab. In terms of the rebuttal to Mallet, there was the engineer, Jerry Krim, who testified that flooding destroyed the home, and I refer the Court to our brief at pages 3 through 4, which summarizes that testimony. The indemnity rule. Florida doesn't apply the indemnity rule. That means simply that if you buy a policy, it's a value policy. That's why we have the VPL in Florida, because it's correct. We are not an indemnity state. That does not mean that insurance is not indemnification. The Springfield v. Boswell case, the Lapata and Rutherford case that they rely on, those are all multiple policies, single peril. Those cases have no application here. Those cases don't trigger the analysis that applies to this case under the Florida Supreme Court's case in Cox. Indemnification is still a principle that governs insurance in Florida. The Third District held almost a half a century ago in the De Cespedes case that the primary purpose of insurance is to indemnify the insured against loss. That's at 193 Southern 2nd at 226. Even earlier, this court said in National Casualty versus General Motors Acceptance Corporation, insurance policies are construed liberally in favor of the insured and strictly against the insurer to the end that the dominant purpose may be accomplished according to the fair purposes of the contracting party. Coverage for profit creates a moral hazard that the courts have routinely condemned in Florida. We respectfully request the Court to reverse and remand with directions to impose the set-off as required by Cox.
Thank you, counsel. Thank you.